Hello, and welcome to this interview for the Institute for Transnational Arbitration Academic Council series titled What I'm Working On. In this series, members of the ITA's Academic Council share information about their recent publications and works in progress. My name is Victoria Sahani. I'm Associate Provost and Professor of Law at Boston University and a former chair of the ITA Academic Council. It is my absolute pleasure and delight to have the opportunity to interview my friend and colleague, Professor George Bermann. Professor Bermann is the Walter Gellhorn Professor of Law and Jean Monnet Professor of European Union Law and Director of the Center for International Commercial and Investment Arbitration at Columbia Law School. You can read Professor Bermann's illustrious biography online, and I also invite you to watch the recording of Professor Bermann's fascinating interview in the ITA Academic Council series, Preserving Perspectives, International Arbitrators in Their Own Words, where Professor Bermann was interviewed by Professor Andrea K. Bjorklund, Associate Dean of Graduate Studies, full professor, and the L.E. Fortier Chair in International Arbitration and International Commercial Law at McGill University Faculty of Law. So I encourage you to check out that interview. We are here today to discuss Professor Bermann's recent book, Twilight Issues in International Arbitration, published by Wolters Kluwer in 2023 as part of the International Arbitration Law Library series. So first of all, congratulations on publishing your book, George, and thanks so much for joining me today to talk about it.
Sure, Victoria. It's a pleasure, as you know.
Thank you so much. So I love the adjective that you use in the book's title, Twilight. So what are Twilight issues in international arbitration, and what prompted you to write this book?
Well, let's start with the term, okay? The term Twilight. I chose the word Twilight, obviously, deliberately. It's not a word that leaps to mind in the international arbitration vocabulary. But the issues that I'm about to talk about are issues that lie somewhere between substance and procedure. So they're sort of intermediate between, let us say, night and day. But more directly, they are serious issues that arbitral tribunals find themselves, surprisingly, rather in the dark when faced with them. So Twilight Issues was really serving two purposes, the term. Substance, procedure, dichotomy, but also the fact that tribunals are in the dark or somewhat in the dark, which I hope I can explain to you as soon as you'd like me to.
Yeah, wonderful. So could you give us an example of a particularly interesting or challenging Twilight issue in the dark, so to speak, that you encountered while sitting as an arbitrator, and how did you handle it?
Okay, I'll be glad to do that. Maybe I should first, if you don't mind, sort of give a very, very, very brief idea of what Twilight issues are meant to be.
Sure.
Excuse me, before I give examples.
Sure.
Based on my experience as an international arbitrator, but even more so as an expert witness in international arbitration, I've been confronted with very common recurring issues in international arbitration, scores of them, as to which tribunals are somewhat in the dark as to what to do on these fronts. Even though they are common, even though we experience them all the time, tribunals don't quite know what to do, meaning they don't know quite what body of law or what body of norms should be consulted in facing these issues. Now, Twilight issues are a very mixed bag, but what they have in common is that they not only recur, as I just said, with regularity, but also because they are not the subject of any provision, either in the arbitration agreement or in the lex arbitri or in the rules of international arbitration. Now, those are the three sources to which an arbitral tribunal might resort when faced with the issues I'm about to illustrate. So what I have in common in some is that we have no fixed norms for these, important though they are, when we consult the three principal sources that tribunals consult. And I want to emphasize that it comes out of not just struggling as an arbitrator, but being put to work as an expert witness to advise tribunals as to how to approach these. And you'll see in a moment, my advice always is to either identify a body of law, one jurisdiction or another, to help us operationalize these twilight issues, or to acknowledge that there are international standards to be used, or that these are matters that we decide on the basis of common sense. So those are the three avenues we go down. Let me just say, though, that if we're going to do the first, that if we're going to look to a body of law to find the answers, we have many options. The most obvious are the law of the contract, lex causae, the law of the seat of arbitration, lex loci arbitri, the law of the place of probable enforcement of the award, if we know it, and the law that we might arrive at by applying our own favorite conflicts of law principles. So there really are competing bodies of law on these. Now, it's time I gave you some examples. Let me start with one of the most obvious that people do talk about, and that's the law of privilege. Now, I can honestly say that tribunals don't know what to do. They don't know whose law of privilege ought to be consulted in deciding whether a party is entitled or not to invoke a particular privilege. Even the IBA guidelines on the taking of evidence in arbitration, when it comes to privilege, you know what it says? Privilege is subject to the law that is applicable to privilege. Okay, now that's just slightly tautological, but that tells you even the drafters of the IBA guidelines really did not know what a tribunal should do with privilege. Now, in the book, I take every one of these twilight issues and I canvass the alternatives. So I think it's really pretty interesting. Another example, one we hear about a lot, is res judicata. An arbitration may be brought on a claim that has arguably already been adjudicated. What are the elements of a res judicata defense? Okay, it's not obvious. Okay, one that comes up rarely but is fascinating is when, if ever, may a tribunal apply a body of law that the parties did not choose on the ground that that law is mandatory. Now, this doesn't happen that often. I happen to have had it on at least one occasion. But the application of the mandatory law of the jurisdiction whose law the parties didn't choose. Now, back to more familiar ones. It may come as a great surprise to people that there is no settled understanding on the law that governs the binding effect of an arbitration agreement on a non-signatory. We talk about it all the time, but there is no fixed understanding, and far from it. Now, what's ironic about all of these, and I have others to give you, but what's ironic about all of these is that every one of these arises on a regular basis in national courts. Regular basis. But on every single one of these, those national courts have forum law. You're in a court of a given jurisdiction, a privilege issue arises, that court will apply forum law. Res judicata, it will apply its conception of res judicata. It will decide, even the restatement of conflict of laws tells us when the mandatory law of a jurisdiction other than the jurisdiction whose law the parties chose may be applied. So this is like a grim reminder that tribunals have no forum law. And I don't think we give that sufficient attention. They just don't have forum law on these issues. They even include rates of interest. I can tell you that tribunals, you probably know this yourself, Victoria, they have no firm idea, and there is no settled expectation about what should be the law of interest applicable to an award. I could go on and on with my examples, but let me just say that on some of these, it is plausible that you would say, we're going to apply, or we should apply, if we must, the law of the contract.
Yeah.
Okay. Now, I, for example, would apply the law of the contract to the question of another Twilight issue I haven't mentioned, which is whether a party waived its right to arbitrate by what it has said or what it has done. Waiver of the right to arbitrate is a standard issue, and I try to make the case in the book that the sensible source of law for that is the law of the contract, because the waiver of rights under a contract is a question of contract law.
Right.
If you go back to, maybe you can remember your course in contracts, it is possible, it's not certain, but it's possible that in that course was discussed waiver of contractual rights. So I'm giving you an example, if you will, of a Twilight issue where it makes some sense when we're looking for guidance to look to the law of the contract. On other ones, we really do want to look at the law of the seat. There's no question about that. Those are the ones, and I identify them in the book, where how you decide might end up determining whether your award survives or not. I mean, frankly, a court might annul an award if you issued it against a non-signatory that the court believes was not bound by the arbitration agreement and shouldn't be bound by it. So the law of the seat, whenever there is a Twilight issue that could lead to the annulment of an award, depending on how it is answered, then the law of the seat comes to the fore. And to a lesser extent, so does the law of the place of probable enforcement, because it may deny enforcement of an award against a non-signatory. So I'm giving you an example of where we might look at the law of the contract, the law of the seat, and the law of the place of probable enforcement. I don't have time to go through all. You have more questions for me, so I'm sorry about the monologue, but I thought it was really good to get this out there. A really classic one is what law governs the arbitrability of a dispute. That's a big issue. Now, the UNCITRAL model law tells us in Article 34 that the court of the place of annulment applies its arbitrability law to the arbitrability of the dispute. And Articles 36 and the New York Convention says the court where the award is sought to be enforced applies its arbitrability law. And by extension, I bet the court that is asked to enforce the arbitration agreement in the first place, before there is an arbitration, if asked to deny an order to compel arbitration on non-arbitrability grounds, would apply its non-arbitrability law. But what should a tribunal do? What is the tribunal's rules? Do tribunals have arbitrability rules? The answer is no. They have no arbitrability rule.
Right.
And so I have a solution. You apply the law under which the claim arises. The law under which the claim arises is the law that has the greatest claim to have its arbitrability standards apply. And that is what the tribunal should do. Now, I hope this hasn't been tedious for you, but
No, it's fascinating.
there are dozen more. I have adverse inferences.
Mhm.
Okay. Now, if you don't mind my going on a little bit longer,
Sure, please do.
but we then have to decide whether no national law should be applied because we think an international standard has emerged.
Mhm.
And
Yes.
I find some Twilight issues that are understandably governed by international standards. And then the book goes into the question of where we get our international standards. Where do they come from? How do we know that we have one? And what are its sources? And
Mhm.
finally, I confess that there are Twilight issues where the law is irrelevant. It's a matter of common sense.
Mhm.
Okay. Was it futile for a party to comply with a condition precedent to arbitration, a requirement to mediate, and the party says it was futile? Well, I don't really think we're going to apply some jurisdiction's body of futility, though we could. But there, I put that in the category of let's use arbitrator good judgment. So I wrap this up. I'm sorry to be so much of a soliloquy here,
Oh, it's a delight.
but I think that gives you the whole picture. And I'll
Yeah.
stop there, and maybe you have a follow-up question or two. But it was
Yes.
necessary to say all that for the book to be understood.
Absolutely. And that's actually why the first two questions I asked were the questions that I asked because I wanted to get out what are Twilight issues? What are some examples? Why is this so difficult? And your response has really highlighted one of the key features of arbitration that is also raising the issues of Twilight challenges here, which is the territoriality, right? So we
Yes.
have courts have a territorial jurisdiction, they have a body, they are grounded literally in the ground in their territories, and arbitration kind of floats across territories, crosses boundaries, and this leads to sort of an interaction between
Yes.
the various territorial powers that exist, the governments, the courts, et cetera, and the international arbitrators who are convened by
Yes.
contract, but in a very ad hoc kind of way. Even
Yeah.
in administered arbitration, it's very ad hoc in terms of the
Yes.
body of law, and you're sort of gathering together.
And the purpose of this book was
Mhm.
to concretize that.
Yes.
You have stated a very valid general proposition, but my goal was to concretize it by taking issues that we confront regularly and say, well, we have to come up with a norm. Where are we going to get it?
Mhm.
Now, people might disagree with my prescriptions. I'm sure they will, but I do give some prescriptions.
Mhm. Mhm. One last question then. Do you think that this ambiguity is beneficial or harmful or some mixed
Right?
bag to the legitimacy of international
That's a
arbitration?
wonderful question. It reminds me of the debate about soft law.
Mm-hmm.
Soft law is, by the way, one of the sources of international standards.
Mm-hmm.
Obviously, I didn't get to talk about what the sources are, but that's one. And the debates there. We commonly hear we have too much soft law because we're shackling the arbitrator. We're shackling the arbitrator, and we're losing the flexibility that arbitral tribunals are meant to deploy. I think that is really related to your question,
Mm-hmm.
very much. Now,
Definitely.
we all have our prejudices about this. Based on my experience, want greater certainty than we have.
Mm-hmm.
I want greater certainty than we have. And therefore, I would like there to be norms that parties can build their expectations on. Remember, it's not just the tribunal that has to resolve these decisions. Counsel has to argue them.
Mm-hmm.
Counsel has to argue them. And what will they argue? And what will be the principal basis of their argument? So this whole mission was predicated on the view that we are better off with more guidance than less. Not everybody agrees, and we shouldn't treat soft law as binding. It isn't.
Mm-hmm.
And so that is the way I think out of the puzzle, that soft law is an inspiration. But if the case doesn't call for what the soft law prescribes, we're not shackled
Mhm.
by it. So I've given you a direct answer, I think,
Yes,
where I
absolutely.
stand on the flexibility front.
Mhm.
And I have very dear friends in the field when I embarked on this project who said to me, "You're wasting your time. You're wasting your time. When we choose arbitrators, we choose smart people. We choose people whom we trust and in whose judgment we trust. So let's just leave it there." Right? Now, some of our listeners may be of that view, but that's really lies at the heart of this enterprise.
Mhm. Wow, thank you. That's phenomenal. And I love how you said soft law is the inspiration. I think your book is very inspiring. And I love that you have taken on this really challenging issue and tried to put some guidance out there for arbitrators, particularly new arbitrators who may not
Yes,
yet have built their instincts and their good judgment. To your point, you talk about common sense and good
yeah,
judgment. Okay,
but
we
that
need
comes
to
with
be able to,
time.
exactly, it comes with
Yeah,
time. And so it's good to have your book as a reference point for those who are new
thanks so
to
much.
arbitration. So thank you so
If you
much for
don't read
speaking
the
with me.
book,
Yeah.
if someone doesn't want to read the book, read the foreword by Gabrielle Kaufman-Kohler. Okay.
Okay.
Okay,
It's a good tip for our
that won't take as
listeners.
long. And
Right.
she really gets it in very nice
Mm,
summary form in the foreword.
that's great. Well, thank you for the tip. And I hope everyone out there listening at least reads the forward if they don't have a chance to read the whole book. Thank you so much again for speaking with me today, George. It's been a delight. And everyone listening, please read the book, Twilight Issues in International Arbitration.
Thank you, Victoria. It's been a great, great pleasure, as I
Thank you.
expected it would be.
Wonderful. Thanks so much.
Thank you.